Clerk can call the court to session, please.
The Court of Appeals for the 8th District of Texas is now in session.
Welcome. We're here today on one case from Winkler County, In re Plains Pipeline LP and Plains All-American Pipeline LP, a mandamus proceeding. For relators, I understand that Mr. Pierce will present. Is that correct?
That is correct, Your Honor.
Thank you. And for the real parties in interest, Winkler Land LLC and Winkler Services LLC, I understand Mr. Schumacher will present. Is that correct?
That is correct, Your Honor.
Wonderful. Well, we're here today presenting oral argument on Zoom pursuant to the Texas Supreme Court's orders on our procedure in this interesting time. And so everyone knows we are being live streamed on YouTube. And with that, Mr. Pierce, you may proceed anytime you are ready.
Thank you, Your Honor. If it pleases the court, Mr. Schumacher, I represent the relators, Plains Pipeline and Plains All-American Pipeline. Actually, I'll only be speaking about Plains Pipeline. Today, the court is asked to consider whether the trial court abused its discretion in ordering at least 3 weeks of invasive entry and testing on a crude oil storage facility operated by Plains. This is a 160-acre area that's in issue here, a quarter section. Plains for decades now has operated a large, very large crude oil tank farm. There are presently 9 270,000 barrel crude oil storage tanks and a lattice of 11 pipelines, high pressure pipelines that cross this property. There is an evidence, by the way, at pages 30 and 31 of the mandamus record, 2 aerial photographs that are the best in the record to show exactly the extent of the various facilities that are on this property. And I'll just refer the court to those. They show that this 160 acres, this quarter section, is pretty much covered with the various tanks and equipment that is necessary for the processing of the crude oil, which, as I think I said earlier, is owned by third-party shippers. Plains is a pipeline and a handler of all this in excess of 1 million barrels of crude oil a day that belongs to other parties. Plains holds a surface lease on the 160 acres. It's in issue, in evidence in this case at page 133 of the mandamus record. Winkler, the primary real party in interest here, wants to enter the property to drill test holes, 1,000-foot deep test holes, and the court permitted 7 of those. The record reflects it'll take at least 3 days for each one. So we're talking about 3 weeks that Winkler Services drilling contractor would be on this property in the middle of ongoing operations. The record reflects that there are in excess, I think it says 140 to 180 individuals out there, at least at the time of the hearing. Because of construction, Plains was in the process of constructing additional pipelines. And I'd like to begin with an issue that I think, while the real parties in interest casually dismiss it, I think it is quite important here. And that is the fact that Winkler Services claim, the basis, the premise of its claim, that it has any right to produce groundwater that is under the 160 acres, and certainly to enter onto the property for the purposes of testing or drilling, is based on an allegation that it holds a groundwater lease from Roark Ranch and the Roark family, which owns the 28,800 acre Roark Ranch, in the middle of which this 160 acre quarter section sits. Now, the problem here is that the groundwater lease, on which Winkler Services relies, the premise for all its claims and what's an issue today, is not in evidence in this case. And this, I submit, is a very, very serious evidentiary failing on the part of Winkler.
Counsel, if I could interrupt you.
Surely.
I mean, it seems to me that in the discovery process, that would be like the first document that you would ask for. And that if it did not exist, we'd probably be here on a summary judgment type motion. I mean, isn't there an affidavit in the record that says that they have some interest?
There is, Your Honor, and I hope I was clear in the brief in a footnote, I believe footnote 2 in our mandamus petition. I said, Plains does not contest the fact that Winkler Services holds a groundwater lease. It was produced. There are many copies of it. The problem is it's not in evidence before the court. And therefore, the court cannot know what it provides in particular as to the relative rights of the parties. And that's a significant issue, as I presaged or suggested in the mandamus petition. I have been schooled for many, many years not to go outside the record. And I won't do that unless I'm asked to. But without knowing what that surface lease says, what that groundwater lease says, whether it is expressly subject to plain surface lease, there is an evidentiary hole here that the trial court filled with no evidence and that this court does not have before it. And this court has confronted this several times. There's the N. Ray Velez opinion where the court said that it's an abuse of discretion to grant discovery based on a document that is not in the record, to assume facts that are not in the record. And the trial court, I submit, necessarily did that here. A more telling case is the Sun City gun exchange case, which this court may recall, which was itself a mandamus action relating to a request to inspect. The party that wanted to inspect in that case, a creditor, claimed that it had the right to do so under a security agreement. The security agreement itself was in evidence. The problem is the exhibit that listed the collateral was blank. And that is where, if these guns had actually been subject to that security agreement, they would have been listed, but they were not. It was blank. And this court said that to the extent the trial court relied on that document for the rights of these parties to enter the gentleman's home, and I think it was bunker, to make an inspection, that was an abuse of discretion. Now, moving from that issue, which again, I can't add anything without going outside the record, which I don't intend to do. I will move to the standards that are an issue here.
Well, before you, Mr. Pierce, before you move, are you controverting the affidavit that was in the record.
The affidavit merely says that they have a groundwater lease. I don't dispute that. The problem is, what does it say? Is it subject to the pre-existing surface lease? Which is my suggestion, but I can't go farther than that without venturing outside the record, because the groundwater lease was not introduced at either of the hearings that were held in this case. This is a request for inspection and indeed for invasive testing under Rule 196.7. And as the court knows, that rule does not expressly set forth a specific standard for consideration by the trial courts. But this court and other courts of appeals have, to a court, crafted two standards. The first is that because of the unusual nature of this type of discovery, going on someone's property to begin with, and here doing things like having third parties out there for 3 weeks in the midst of ongoing operations, there are unique burdens and risks that require the trial court to do two things: conduct a greater inquiry into the necessity for the testing, and second, balance the degree to which the testing and the sampling have evidentiary value when balanced against the burdens and the dangers created. This testing, this entry on the property and drilling of these test holes was unnecessary for several reasons. The first is, and this is undisputed in the record, Winkler Services has employed an expert hydrologist, Mr. Thornhill. And in the record is testimony and documentary proof that Mr. Thornhill, using the best available government information, which is a Texas Water Development Board study referred to as the BRACS study, which has all the information that is available, has determined the volume of groundwater under this 160 acres. In fact, he has determined there are 24,210,729 barrels of recoverable water under this property. The volume of water and the recoverable water is not an issue here.
Counsel, can I stop you there, because
Sure.
I just want to make sure I get your response to what I perceive to be their strongest argument on the need is that if indeed they have a right to drill on the 160 acres for water, and I don't expect you to concede that, but assuming that they have that right and you also have the right to operate your gathering facility, that there's going to have to be some sort of accommodations made about where individual wells could go, that both they could produce and that they wouldn't interfere with your right to conduct your activities. So, I mean, it seems to me that that's kind of what their argument is they said, we want to test in these 7 places and find out which, if any, would be an ideal slot for them to have a producing well. So if that's the purpose, because I guess that's one of the issues that might be before the trial judge, why wouldn't they have a right to do these test holes to see which of the 7 might be the most ideal place?
Well, the court is correct. This case on its face raises the reasonable accommodation doctrine if, and again, I apologize for returning to where I started, if they have the dominant estate. And we don't know that on this record because their groundwater lease is not in evidence. But to more directly respond to the court's question, if they, Winkler, were able to establish that the reasonable accommodation doctrine applied and they were entitled to drill on the property, the question is whether this testing is necessary to do that. Again, this is not a blank slate out there. As the court can see from those two exhibits at pages 30 and 31 of the mandamus record I mentioned, most of the space out there is gone. It's near impossible or near impossible to drill anything because of what's already in place, not to mention what may be constructed in the future. Therefore, the trial court would probably order, if all of the facts were determined in their favor at a trial, that Plains must reasonably accommodate them by permitting them to drill in areas where drilling is possible. These test holes on this record are not for that purpose. Mr. Thornhill testified at length that the reason he wants this information is to be, and I'd like to orally underscore and possibly underline the word precise. He has said repeatedly that he wants precision for the development of a drilling plan. And that is important, the term drilling plan, because when the record is reviewed, his drilling plan is a plan on how the wells will be designed, how they'll be cased, how they'll be screened. This goes beyond the question of where the water is. But for purposes of Rule 196, we also have to look at Rule 192.4, which is an additional limitation on discovery of this type. It says that discovery should be limited if it is unreasonably cumulative or duplicative, or if it's available from a more convenient or less burdensome source. And what the record reflects here is that Winkler has had and presently has the ability to drill these test holes virtually all the way around the perimeter of this 160 acres, but outside the fence line, if you will. And Mr. Thornhill himself, while he says, I want to get right in the middle for the additional precision to develop my drilling plan, he has conceded that there would be useful information to be gained from drilling these, what I'll refer to as perimeter holes, if I may, outside the property. But they can get within, I think the record says 50 feet. His holes are 600 feet apart. A great deal of what they are asking for can be obtained based on the record by drilling outside the property. Certainly they have not taken the step. I mean, that's what strikes me in this case. They concede we could drill these holes all the way around the property and we'll get information that goes into the property. But they haven't drilled a single one. And I I have a brief apology for the court. I can't tell from the record I have how legible some of the exhibits are. I have taken what was plaintiff's exhibit 8, found at page 531 of the record, and put on it where these holes are. These are holes 1, 2, and 3 across the north. About, it looks like 200 feet off the fence line. Holes 7 and 6 are down the same distance off the fence line to the south. And then we have 2 holes, 4 and 5 in the center here. My copy, it was hard to read those, and I hope that that might assist the court a little bit.
Yeah, I have the same one, and thank you for that clarification.
All right. At this point, they don't know what information they have available to them without inspecting. And they won't know unless they drill some of these holes. And additionally, and see what they require. I mean, Mr. Thornhill conceded if they all show the same information, that tells you a lot. All of this, when the record is considered as a whole, is directed toward the formulation of a drilling plan. Now they say, well, what about our damages? We're going to have damages on a nuisance claim and a tortious interference claim. The measure of damages for a nuisance claim is market value. To the extent the water affects market value, they know the total volume of water. Tortious interference would be the same measure of damages that would put them, or the damages that would put them in a position had the contract not been interfered with. The contract they claim is the groundwater lease, which covers 28,000 acres. To determine what this one little quarter section, how that would affect the value of the entire contract, under Mr. Thornhill's testimony, that would require drilling tens of thousands of test holes over this entire area. So you can see, okay, what's the value of the hole? How much do we lose on this 160 acres? That is not a basis in my judgment. Now, the risk here against which this testing must be balanced. We have got 1 million+ barrels of oil. It's moving in high pressure pipelines. There is extensive electrical out there. There are employees all over the place and contractors working. Since 2017, they've had 4 incidents with vehicles hitting equipment or underground objects while excavating. 2 of them involved excavation where they hit an unmarked underground pipeline. And the record is there are unmarked underground pipelines out there. We don't know where they are. They go back conceivably to the 40s, the 1950s. I mean, people have been out there forever. We've got construction, bulldozers, cranes, all sort of equipment out there. This is a very, very dangerous situation if something goes wrong. And we mentioned, we put in the record the master services agreement that Plains requires for any contractor of its own to come on the property, and the indemnity obligations. As the court knows from the record, the driller that Winkler proposes to use says, I'm not going to indemnify you against any of this. I can't guarantee we're not going to hit a pipeline. He conceded vacuum trucks have exploded in the past, not on this property, but it happens. Somebody could be backed over. And this is a real concern. If I may, again, put up Defendant's Exhibit 7, and I'll get it close to the camera here. Running right by pipelines 4 and 5 is an active high pressure oil pipeline. while it's harder to see, well, test hole number 5 appears to be on a roadway. This, no one knows what might happen. But if something bad happens, given the high pressure pipelines, the volume of crude oil that's stored out there, this could be catastrophic. And that is the risk, the danger against which the trial court's order, which on this record is basically premised on the idea, well, they can do a better drilling plan. They can figure out how to design the wells better if they have this information. In our judgment, that comes nowhere close to equaling, much less exceeding, the risk and the danger here. And we therefore are asking the court to grant the writ of mandamus and order that the trial court vacate this order that permits 3 weeks of invasive testing on this active, volatile piece of property.
Thank you, counsel. Mr. Schumacher.
Thank you, Your Honor. May it please the court. My name is Clint Schumacher with the law firm of Dawson and Sod, and we do represent the real parties in interest, Winkler Land LLC and Winkler Services LLC. In this petition for mandamus, which seeks to overturn a trial court's discovery order, the standard of review, as counsel has said, is a clear abuse of discretion standard. And as the Texas Supreme Court told us in Walker versus Packer, and as this court has said in re Celadon Trucking and cases subsequent to that, on a clear abuse of discretion standard with respect to the resolution of fact issues or matters committed to the trial court's discretion, a reviewing court may not substitute its judgment for that of the trial court. This court also said in Celadon Trucking that the relator, here Plains, must establish that the trial court could reasonably only have reached one decision, even if the reviewing court would have decided the issue differently. It cannot disturb the trial court's decision unless it's shown to be arbitrary and unreasonable. The trial court order that Winkler seeks to overturn, or that Plains, seeks to overturn, Your Honor, is at pages 632 and 633 of the record. In it, after hearing 2 days of testimony, the trial court wrote as follows: the requested discovery is within the scope of discovery. The requested discovery is of minimal interference and burden to the defendants, here Plains. The necessity of the information to be gleaned from the inspection outweighs any burden to the defendants. And then finally, the request meets the requirements of Rule 196.7. Then the trial court set out with specificity how that inspection would take place and gave Plains specific protections to ensure that it could be done in a safe manner. These are very specific findings that are supported by the evidence. They are not arbitrary. They are not unreasonable. In fact, the first time this was presented to the trial court in a more expansive inspection plan, the trial court denied the discovery and granted Plains' objection. At that hearing, Your Honor, Plains presented testimony from its district manager, Mr. Justin Nicholson, who testified that he knew more about the operations on this site than anyone in the courtroom that day. He had not yet been deposed in the case, but he testified to the court about his concerns about the interference with Winkler's discovery plan and the ongoing operations at the site. After the trial court denied the discovery, Mr. Nicholson's deposition was taken to get a greater understanding of the operations on the site, and more specifically, where test holes, temporary test holes, could be placed with minimal to no interference to Plains' operation. After getting that testimony from Mr. Nicholson and consulting with its expert hydrologist, Winkler presented this revised and condensed plan back to the trial court, along with the testimony of Mr. Nicholson talking about these 7 hole locations specifically. Only then did the trial court grant the discovery request made by Winkler. Additionally, at this second hearing, one of the witnesses at that hearing was Winkler's well drilling contractor, Mr. Randy Taylor, that Mr. Pierce has referenced. Mr. Taylor, a very experienced water well driller in West Texas and in the panhandle of Texas, explained to the court how these wells could safely be drilled, the precautions that would be taken to find unmarked and out of service lines, and how these were not unusual procedures in West Texas. I think it's also important to note in the trial court's order, if there are active lines, the lines that Mr. Pierce has referenced, the high pressure lines where you've got product flowing, all those will be marked, for surely Plains knows where those are located, and those lines can be avoided. Your Honor, only after, or Your Honors, only after the trial court heard this testimony, the careful placement of the test holes, understood how the drilling could be done safely, only then did the trial court grant the discovery request. This was a very deliberate and reasoned decision, and this careful decision of the trial court should be upheld. There's no basis to overturn it, particularly on a clear abuse of discretion standard. But Your Honors, even if there were a clear abuse of discretion by the trial court, and we clearly do not think that to be the case, but even if there were, as the party seeking mandamus, Plains bears the burden of establishing why they lack an adequate remedy at law sufficient to justify mandamus. Plains only says very briefly at the very end of their brief that mandamus has been granted in another Rule 196.7 case by this court in re Sun City Gun Exchange, a 2017 opinion. And in that opinion, this court said an appeal is inadequate in the context of a mandamus when the parties are in danger of permanently losing substantial rights. And then this court identified 3 circumstances where that could be the case. But none of those circumstances exist in this case. The 3 circumstances are these: a circumstance where the appellate court could not cure the error. We often see this when a trial court orders disclosure of confidential or privileged information. Obviously, once the bell is rung, it can't be unrung. In the Sun City Gun Exchange case, that was weighing on this court's mind, in fact, where the parties there, and I think this is important, the parties were going to enter the house of a non-party, a gentleman named Mr. Bristow, and obtain information from inside his house, more specifically, whatever guns and potentially ammunition he had in his house or in a bunker that was described to be in his house. Well, once that information was out, it couldn't be put back. And ultimately, the court said that was a basis for granting of a mandamus in that particular instance. But Your Honors, we don't have that here. Both parties will benefit by knowing what is right now an unknown fact. What does the world look like underneath the surface? What does this water formation look like? And if there is error, by granting this request, it can be remedied on appeal. If for some reason, and again, we don't think this is the case, it's error to have that discovery information. And that discovery information makes its way into a trial record. And that results in the trial reaching an incorrect decision. This court can remedy that on appeal by sending it back to be retried without that information in the record.
Counsel, can you address this issue about the master services agreement? Assuming that Plains has lots of contractors out there on a daily basis and they've all signed off on an agreement that I guess would have specific levels of liability insurance and specific indemnity obligations, why wouldn't your contractor going out to the work site not be obligated to execute the same agreement?
Your Honor, a couple of responses. Number one, that's not required by Rule 196.7. Second, it was not requested of the trial court. But third, Your Honor, and this is to some extent the crux of the case, Plains has elected to build its facility on a property where the surface is owned in part by Winkler Land and where the water is owned and leased by Winkler Services. They've elected to make this investment on top of property that they don't own in total. In that instance, Your Honor, we have competing rights. And under the rights that we have, most notably, we are, as the owner of the groundwater, we have the superior right to the surface. and have the ability to come onto the surface to drill for water. In that instance, Your Honor, we don't have to, unlike a contractor, we don't have to enter into a contract with Plains to do that. As a result, it's unnecessary to enter into a master service agreement. It's not required. It's not within the obligations that we have either under the discovery rules or under any type of common law. There are cases, Your Honor, where a trial court's ordered a bond. That was the Enri Sweppy case. But again, Your Honor, that was not a request that was made by Plains, and quite candidly, that's not a requirement of Rule 196.7, which is the discovery rule that we are relying upon to enter onto the property to do our inspection. Your Honor, I want to follow up on a question that you asked Mr. Pierce with regard to why do we need this information. I think Mr. Pierce had indicated that Mr. Thornhill's testimony was not clear with regard to this information, the drilling information being necessary to develop a well drilling plan. And I pulled out, Your Honor, Mr. Thornhill's testimony on that point, which is at pages 279 and 280 in the record. And I'm going to read specifically, Your Honor, at page 279, beginning at line 16, where the question is asked to Mr. Thornhill, and would the data, the test hole data that you propose in your plan, which we will get to in a minute, give you more information with respect to developing a drilling plan insofar as where you would locate actual production wells at some point in the future as well? And Mr. Thornhill responded this way at line 21. Absolutely. Again, based on the information we have, there is considerable difference in thickness, total saturated thickness across the property based on the course data that we have. So I would absolutely need to see a lot more before I would want to recommend where to put wells to produce water, how many wells, and how long those wells can last, what the total production would be, those types of things. But Your Honor, Mr. Thornhill was not the only expert that testified that way that day, the second hearing day in front of the court. Plains also had a hydrology expert who presented. And on cross-examination, he was asked, would you have enough data from outside the 160 acres to make a recommendation as to where to put production wells? And he said no. He was then asked, what more would you need? And he said, more data. So, Your Honor, there is a very clear need for this data for the trial court to do what it is going to be asked to do, which is to come up with a plan to deal with these competing rights between the property over the same 160 acres. Mr. Pierce, in his argument, referenced pages 30 and 31, which are indeed excellent aerial photographs of the property. And one of the things that certainly the trial court found and was within their discretion to find, and this court can judge with its own eyes, is there's a lot of space out there. We've talked about various pages in the record where the 7 test holes are located. I happen to pull out page 227 that's in the record. But there's a lot of space in which to do this well drilling, and certainly the trial court determined that it could be done with minimal interference and burden to Plains, and the evidence supports that judgment by the trial court. Let me touch on, Your Honor, some of the other evidence before the court. I read some of it about the necessity of the information. Again, we're looking at pages 279 and 280 of the record.
I think,
Counsel, yeah.
yeah.
I have a question. My sense of your argument is it feels a little bit like we're getting the cart before the horse, because I understand what you're proposing is a necessity in that the drilling plan, but the court will need that information, I believe, probably at some point, if in fact the lease on which you make the claim of the groundwater, if you prevail. I guess what I'm failing to understand is, why is that necessary at this time?
Justice Rodriguez, at the end of the second hearing, and you'll see this in the record at the very end, in fact, Mr. Pierce made that same argument to the trial court. And the trial court raised the issue of bifurcation. And when the trial, or Mr. Pierce, in fact, suggested a bifurcation, and the trial court's response is that it would consider bifurcation if it was coupled with an injunction against continued construction on the site to ensure that the site was not completely built out, thereby restricting or eliminating Winkler's ability to drill water wells on the site. And Justice Rodriguez, when the trial court proffered that, Plains very quickly backed off the idea and did not want to put the brakes on their building project. Here's why that's important, Justice Rodriguez. Plains has testified. In fact, let me get the site to cover that point. Plains has testified, and this is on pages 56 and 57 of the record. At the first hearing, one of Plains's in-house lawyers, a gentleman named Mike Jones, testified that right now, at that time, Plains had built 5 tanks. And I think Mr. Pierce referenced that. And then Mr. Jones said another 24 are planned that will take every spot of the property. Well, as Plains continues to build on this site, there are continued then restrictions about where Winkler can place water wells. And so, Your Honor, if this case were bifurcated, that additional time continues to put Winkler at a disadvantage. But in addition, Justice Rodriguez, Plains has had every opportunity, if it wants to bring that legal issue before the court, to do that. It's chosen not to do that. And when the trial court raised the issue, the stipulation the trial court would have put on that was not acceptable to Plains, and so that is why we're here. Let me touch on the issue about the groundwater lease being in evidence. First of all, Your Honors, that was, as Mr. Pierce very candidly said, that is not a disputed issue in the case. It was not a disputed issue in the motion. And there's more than sufficient evidence in the record about the ownership of these groundwater rights, and we can touch on that. But as a discovery motion where Plains was resisting discovery, they had the burden to prove that the discovery was unnecessary, unneeded, overly burdensome, whatever their objection may be. So they carried that burden at the trial court. They didn't complain to the trial court that the groundwater lease in its entirety was not in evidence. So whatever error, if there was any, and again, we don't believe there was waived under Texas Rule of Appellate Procedure 33.1. But as we've said, there was ample evidence in the record of the existence of the groundwater rights and the ownership of the groundwater rights. I believe Justice Alley has referred to the affidavit of David Lynch, which is in the record at W66 through 68, and no objection was made to his testimony about the ownership of the groundwater. In addition, the memorandum of groundwater lease, which contains both the granting clause and the language from a surface easement, is in that memorandum. It's filed of record in the Winkler County Real Property Records, but more specifically, it was Exhibit F to the response to Winkler's, it was Winkler's, Exhibit F to Winkler's response to Plains's objection to the request to inspect. It's in the record at W48 through 54. It was on file with the trial court before the hearing. And it clearly sets forth that Winkler Services has been granted and leased a fee simple determinable estate in the groundwater. And that memorandum in and of itself is in all respects enforceable as it's signed. It has a legal description of the impacted lands and a description of the leased property and the easement rights. Thirdly, there's the affidavit of Michael Thornhill, which also discussed the ownership of the water and was, again, Your Honors, not objected to. The cases that Plains has cited, none of them are discovery cases like this case, with the exception of Gun City Exchange, which we can talk about in just a moment. But Ranger County was a jury trial on the construction and effect of an automobile insurance policy not in evidence. Obviously, that's a problem. Chapman Oil and Gas was a venue hearing where the party seeking to hold venue in the place of performance under a contract didn't put the contract in to support their venue argument. Again, that's a problem. In Hoggett versus Wright, it was a jury trial in a suit to reform a deed. And again, the deed was not introduced, and that was a problem. Now, let me go back to Enry Sun City Gun Exchange, where opposing counsel, Mr. Pierce, argued that there was an issue because the security instrument, the exhibit to the security instrument, was not in the record. And indeed, this court did talk about that. But it's very important to see where this court talked about it, because the party in that case seeking discovery made an argument that said Rule 196.7 is not applicable because we have this right under a security instrument. And the trial or the appeals court said, well, you didn't put the instrument into the record, so I can't rely on that to say 196.7 is not applicable. And then you go into the Rule 196.7 analysis. That's completely inapplicable to the case before the court today. Your Honors, with regard to the argument of, well, why can't you just go outside across the fence line? Again, this was an issue left to the good discretion of the trial court. And here was the evidence that was before the trial court. First, that the water-bearing strata, the formation where the water is variable over short distances. And this is in the record at page 270, 271, and 279. So what it looks like outside the 160 acres may be very different from what it looks like even 300 feet inside the fence. And that's in the record at page 341. Further, even if the formation were the same, even if the formation underground were the same, what that formation is made out of also has a very real effect and can be very different. If the water is sitting in clay here and the water is sitting in sand over here, water is produced, has been explained to me and it's in the record, water is produced much more easily out of the sand than out of the clay. So not only do you need to know what the formation looks like, how deep it is, how thick it is, what its porosity is, you need to know where's that water sitting. Is it in sand where you can get it easily, or is it in clay? So again, all those are things that must be determined by drilling test holes inside the 160 acre tract. And you know, it's important to point out, I think this is clear in the record, at each of these locations, we're talking about a 60-foot by 120-foot pad that would be used for no more than 72 hours. The drilling contractor comes in, drills the test hole. There's a 6-inch PVC pipe at the surface. The hole narrows to 4 3/4 inch as it goes below the ground. They get the information that they need. They take their samples. They do their kind of underground x-ray, for lack of a better term. And then within 3 days, they're gone and they're off to their next site. And so these are it's a temporary situation that'll only impact for a few days at a time at these 7 locations. Let me address counsel's argument about there being danger at the site. Again, lots of testimony presented to the trial court. The trial court gets to exercise its discretion over that issue. But here's what the evidence was. First of all, the 7 hole locations and how they were picked is very important. Mr. Nicholson testified that hole locations 1 and 3 on, say, for example, record page 227 or the various other places where these hole locations are identified in the record, his testimony was those would, quote, not be a problem. And that's in the record at page 486. Then hole location 2 is simply placed in the same part of the property in between those hole locations 1 and 3. Hole locations 4 and 5 were selected because Mr. Nicholson was asked in his deposition, Mr. Nicholson, if your bosses came to you and said you must pick sites for there to be a temporary test hole drilled, where would you pick? And he identified sites 4 and 5. And that's in the record at pages 498 through 500. In fact, he was asked if you had to find a 5,000 to 10,000 square foot pad for drilling test holes, where would you put it? And that was where he selected. And then finally, with regard to hole locations 6 and 7, Mr. Nicholson said at some point in the future, there will be a water retention pond excavated at that location. So there were no operations at that place, and 6 and 7 were placed there. And in fact, there were some old engineering drawings where Plains itself had reserved that area for a future water well, and that's at page 530 of the record. And then as laid out in the trial court's order, and this was supported by evidence, the way these holes can be drilled safely is, number one, mark the known lines. But then number two, use a probe to check for unknown lines. Big stick, put it into the ground to the depth you would expect to see a line that's unmarked, no longer in use. If you find one, you know not to drill at that place. Then if you need to, you can also use high pressure water to excavate a hole to see what's below ground and whether or not there might be an unmarked pipeline at the location that you had selected to drill. This is a very common method. This is the evidence. Very common method throughout West Texas. This is not the only place where Mr. Taylor or others in his profession have drilled with underground lines. And that's all in the record at pages 478 through 479. Finally, Your Honors, I would say that this is no more disruption than what happens on the site on a daily basis. As the district manager, Mr. Nicholson, testified, 140 to 180 employees and contractors are on that site daily, with 95% of them being contractors. There are routinely track hoes, backhoes, front end loaders, dozers, graders, welding machines, and so on that are on that site. This drilling will not create any more disruption than what happens on that site on a very routine basis and with little to no issue. Your Honors, I appreciate the opportunity to make this argument to you.
Thank you, counsel. Mr. Pierce, do you have any rebuttal?
If I may, Your Honor, Winkler hopes, Plains hopes, that if Winkler were permitted to go out and have a contractor drill these holes, nothing would happen. But this record couldn't be clearer. There is no, pardon me, assurance that something won't happen. There are some precautionary measures, which Mr. Schumacher mentioned, but they don't always work. Or Plains wouldn't have already excavated into 2 unknown underground pipelines. There is no getting away from the fact that there is risk here, and the magnitude of that risk, if something goes wrong, could be tremendous. We have high pressure pipelines, we have flammable materials, we have electrical out there. There's so many things that could go wrong here when the trial court and now this court is asked to look at the risk. So the risk cannot be minimized here in the balancing test. And while Justice Rodriguez may not believe me, I ran out of time before I got the words cart before the horse out of my mouth in my argument. I had planned or hoped to get there. And on that point, remember, this is a declaratory judgment action. Winkler is seeking a declaratory judgment that it has the right to go on this property and drill water wells. There is absolutely nothing that would prevent a trial of this case and probably appeal, at which point the parties' respective legal rights based on the terms of the instruments would be determined. The court can then, if Winkler wins, permit testing and drilling. There's no need, and actually it is improper to do it now. If I may very quickly refer the court to the N. Ray Kimberly-Clark opinion, which is cited in the briefs, and I know the court's very familiar with. While I try to avoid doing it, I'm going to have to read one sentence from this opinion. As a result, the trial court's order, which permitted drilling to look for underground storage tanks, severely compromises or vitiates Kimberly-Clark's ability to present its defense to the declaratory judgment action during a trial, because the trial court's order permits the party seeking inspection to circumvent its burden of proof in the declaratory judgment action by obtaining the relief sought through discovery. That is exactly what we're looking at here. There may be a time for testing. That time is not today. And very quickly, I'll return to the inadequate remedy at law. I go back to this court's opinion, which is presaged in other Kimberly Clark, the Goodyear Tire case. But this court in the Sun City Gun Exchange, all they were talking about was going into this man's house, videotaping the guns. Once that was done, it was done. That's the same we have here, but with a tremendously higher risk attendant upon it. There's no undoing this if it is later determined, say on appeal, that this order was improper. The ball game is over, the horse is out of the barn, and there is simply no way to remedy this. The theme running through this court's opinions and all the others is that a discovery order, particularly a request for inspection that goes beyond what the rules permit, is an abuse of discretion, and mandamus will lie to correct it because appeal is not an adequate remedy. And that, I submit, is exactly the situation that we are confronted with here. Thank you.
Thank you, both counsel, for your excellent argument. Your case will be submitted on your briefs and your argument, and you should hear from us soon.
Thank you, Your Honor.